Good evening, class. I'll continue my discussion on preliminary investigation. First, the definition of preliminary investigation as provided in Section 1. Rule 112 defines preliminary investigation as inquiry or proceedings for the purpose of which to determine whether there is sufficient ground to engender a well-founded belief that a crime has been committed and that respondent is probably guilty thereof and should be held for trial. This was enunciated in fact in the case of Galvez versus Court of Appeal, 671 Escra, page 223. Now, that's the definition. Let's go now to the purpose or purposes of preliminary investigation. What are the purposes of preliminary investigation or purposes of preliminary investigation? Well, the specific purpose of preliminary investigation is one, to inquire concerning the commission of a crime and the connection of the accused with it, in order that he may be informed of the nature and the character of the crime charged against him. And if there is a probable cause for believing him guilty, the state shall take the necessary step to bring him to trial. Then, another is that to preserve the evidence and keep the witnesses within the control of the state. That's letter B. Then letter C is that to determine the amount of bail. So this is enunciated in the case of Calio Claridad versus Esteban. I repeat, to inquire concerning the commission of the crime and the connection of the accused with which, in order that he be informed of the nature and character of the crime charged against him. And if there is a probable cause for believing him guilty, the state shall take necessary step to bring him to trial. Letter B, to preserve the evidence and keep the witnesses within the control of the state. And letter C, to determine the amount of bail. Plain and simple. Okay? If you're going to easily, memorize that in your brain, it's simply in this way. Just to determine that there is a commission of the crime and who committed the crime. And the nature of the crime and the character of the crime class. Then, number 2, of course, you need to preserve the evidence and the witnesses. And number 3, to determine the amount of bail. So these are the specific purpose. Now let's go further, class. What is the other purpose of preliminary investigation? Preliminary investigation is designed to free a respondent from inconvenient, expense, ignominy, and stress of defending himself or herself in the course of formal trial. Now, the question again is, what is the nature of a preliminary investigation? If that is the question asked, your answer would be, it is an executive function, or preliminary investigation is a duty or function of the prosecutor. Then we have the principle of executive function as to the nature of preliminary investigation, like what I said. And of course, it's an executive function through the Department of Justice and the National Prosecution Service under the umbrella of Department of Justice class. Another question is, does preliminary investigation require a full-blown trial? No. Preliminary investigation do not require a full-blown trial. It is only a place where parties are required to submit their respective evidence for the determination of probable cause. It is a substantive proceedings. It do not require what we call full-blown trial where parties will present the respective evidence in proving the guilt of the accused. Here, class, in preliminary investigation, what is determined only is the determination of probable cause. Another is that preliminary investigation is a mere inquiry or proceeding. It do not allow parties to conduct direct and cross-examination, but only they submit their respective evidence in the form of complaint and counter-affidavit. In the course of preliminary investigation, the determination is probable cause only and not proved beyond reasonable doubt. It do not require the exhaustive proceedings like that was conducted in a full-blown trial. Now, another question is that, is the right to preliminary investigation a constitutional right or a statutory right? Well, nothing in the Constitution states that you have a right to preliminary investigation. However, there is a law enacted, that is the revised rule on criminal procedure. It took effect on December 1, 2000. Now, what is the rule under this? Then the respondent, remember this class, when the case is still pending preliminary investigation, we have the complainant and the respondent. Now, the respondent has an statutory right under Batas Pambansa Bilang 129. Okay? And it was amended, class. Then, let's go further, class. Is the right to preliminary investigation can be subject of a waiver? Okay, so kanina, it is a statutory right, not constitutional right. Then this time, another question is that, is the right to preliminary investigation can be a subject of waiver? Yes. The right to preliminary investigation is deemed waived if the party failed to raise it before arraignment or before he entered his plea. Once he pleaded guilty or not guilty to the crime charge, then he has waived his right on preliminary investigation. Now, we have what we call preliminary investigation for determination of probable cause. That's the filing of the information in court. So the prosecutor will conduct preliminary investigation on cases where the penalty imposed on the crime committed is 4 years, 2 months, and 1 day. So I like what I said, preliminary investigation is needed for those crimes where the penalty attached is 4 years, 2 months, and 1 day and above. That is needed for the determination of probable cause. So, preliminary investigation, probable cause. Okay, let's go to preliminary examination. Class, preliminary examination is not conducted by a prosecutor. It is conducted by a judge. For determination of what? for determination of probable cause for the issuance of warrant of arrest. I repeat, preliminary investigation will be conducted by a judge before the issuance of warrant of arrest. Once the case is filed in him, then, or before the court, the trial judge is mandated to conduct a preliminary examination personally by himself for the issuance of warrant of arrest. Now, if the case is a case of inquest proceedings, he need also to conduct preliminary investigation for the issuance of a commitment order. I repeat, if it is a warrantless arrest, if it is a warrantless arrest class, he do not issue warrant of arrest, but instead he issue a commitment order. Let's go further, class. Are courts precluded from reviewing findings of probable cause of prosecutor? The answer is, as a general rule, no. As a general rule, yes, because the determination of probable cause is an executive function, or the conduct of preliminary investigation is an executive function, okay, for the determination of probable cause. However, the court is not precluded to conduct, okay, or review the findings of the prosecutor if, class, there is a very clear evidence that there is really no probable cause. I repeat, as a general rule, the findings of the prosecutor for the determination of probable cause cannot be subject of review by the court, except when there is a clear evidence that there is grave abuse of discretion, or there is a clear evidence that there is no probable cause, in which case, okay, the court can now conduct a review on the acts or findings of the Secretary of Justice, class, as the case may be. Let's go to instances when probable cause need not be established. It is not only in preliminary investigation or preliminary examination that probable cause need to be determined. The court construct in the Philippines, there are 4 instances in the revised penal code of criminal procedure, revised rules of criminal procedure, where probable cause is needed to be determined. 1. In Section 1 and Section 3 of the Rule 112, the investigating prosecutor or officer to determine whether there is sufficient ground to engender a well-founded belief that the crime has been committed and the respondent is probably guilty thereof and should be held for trial. A preliminary investigation is required before the filing of the complaint or information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day without regard to fine.